Have you ever wondered if you must submit the original documents in court? What happens if you lose them? Or you have only photocopies? Is it a strict rule or just a myth? Today, we'll break this down and clear the confusion. By the end of this video, you'll know the legal requirements, your rights, and what courts have to say about original documents. Let's dive in. When filing a case or presenting evidence in court, the question often arises, are original documents mandatory? This concern has become even more significant when key documents are missing, damaged, or unavailable. While Indian courts do value original documents, the law also provides alternatives in specific cases. So, is it really true that you must have original documents, or is it a myth? Understanding the rules around document submission will help you navigate the legal proceedings confidently. In today's video, we will explore the legal positions, exceptions to the rule, relevant case laws, and what you should do if you face this issue. Before jumping into the details, here are the key points we will cover today. First, what does the law say about original documents in court? 2. Can certified copies or secondary evidence be accepted? 3. Important case laws explaining the requirements of originals. 4. Steps to take if you cannot produce the original document. And 5. Recent updates and judgments on the subject. Each point will help you understand when originals are needed and what you can do when they aren't available. Let's get started. What does the law say about submitting original documents? Let's break the myth. Before diving into exceptions and alternatives, let's first look at what Indian law says about submitting original documents in court. Many believe that without originals you cannot proceed in court. However, this is only partially true. Under Indian law, original documents are considered as the primary evidence. This is outlined in the Indian Evidence Act of 1872. First, Section 62 of the Indian Evidence Act. Primary evidence means the documents itself produced in its original form. 2. Section 63 allows for secondary evidence under specific circumstances, but only when the original document is unavailable for valid reasons. So, when are originals required? The general rule is that originals must be submitted when, first, ownership of property or rights is in dispute. 2. Specific clauses or terms of contract needs verification. 3. Authentication of document is challenged. What are the exceptions to the rule? However, there are instances where court allows secondary evidence such as: first, the original is lost or destroyed. 2. The document in possession of another party and a notice has been served to produce it. 3. Certified copies of public documents as allowed under Section 65 of the Evidence Act. So, while courts do prefer originals, the myth that they are always mandatory is not true. Legal provisions ensure fairness even when original documents are unavailable. Here are some case laws and court commentaries which shatters the myth. Now that you know the rules, let's see how courts have interpreted and applied them in real cases. These judgments help us understand the flexibility of the law. In a recent ruling, the Madras High Court clarified that original parent documents are not necessary to transfer property in cases where the title is undisputed. This judgment protects individuals who might have lost original papers due to unforeseen circumstances. Second, the Karnataka High Court in Order 13 Rule 9 has emphasized the importance of ensuring rightful ownership and fairness while handling documents. It observed that accepting secondary evidence should not compromise justice. Judges across India have remarked that requiring original documents in every single case could lead to injustice. Justice Pratibha Singh from the Delhi High Court stated, the purpose of evidence law is to establish the truth, not to punish parties for technical omissions. By analyzing these case laws, we see how courts aim to balance fairness with legal requirements. The myth that courts are rigid about originals is slowly fading. If you are worried about missing or lost originals, don't panic. Let's discuss the steps you can take when originals are unavailable. First, file an application for secondary evidence. Under Section 65 of the Evidence Act, you can submit certified copies, photocopies, or other secondary evidence with a valid explanation for the absence of the original. 2. Serve notice to the opposing party. If the document is in someone else's possession, serve them a legal notice under Section 66 of the Evidence Act to produce it. 3. File an affidavit. Attach an affidavit explaining why the originals is unavailable. Example, lost, destroyed, or stolen. 4. Seek expert opinion. If needed, get the document authenticated by experts or file a report from the forensic expert to prove its validity. 5. Obtain certified copies. For public documents, certified copies are legally valid and admissible in court. By following these steps, you can ensure your case doesn't suffer just because an original document is missing. Courts have recently taken a progressive view regarding document submission. Let's look at the latest updates. First, Madras High Court recent judgment of 2024. The court ruled that original parent documents are not always mandatory for property transactions. This judgment is significant for individuals unable to produce originals due to loss or damage. 2. Karnataka High Court of 2023 clarified that the purpose of Order 13 Rule 9 CPC is to ensure justice and prevent misuse of documents, stressing the courts must balance fairness with procedural compliance. These updates indicate that courts are prioritizing fairness over technicalities, helping litigants overcome practical challenges. To recap, here are the main points. First, Indian law primarily requires original documents as evidence. Section 62. 2. Exceptions exist when secondary evidence can be submitted. Section 65. 3. Relevant case laws clarify when courts allow alternatives to original. 4. If you cannot produce originals, file an application, serve notice, or submit affidavits explaining the situation. 5. Recent judgments show courts are adopting a practical approach to document submission. The myth that original documents are always mandatory in court is not true. When originals are preferred, the law provides flexibility. So, if your originals are lost or unavailable, don't panic. Know your rights and legal options. If you found this video helpful, don't forget to like, share, and subscribe for more easy explanations of Indian law. If you have any legal questions, drop them in the comments and we'll answer them in future videos. See you next time. Take care. Bye.